Good afternoon and welcome to another edition of Wonderful Wednesdays with Wendy. I'm your host, Wendy Wotecki, the Parent Support Connector here at Mission Empower. Mission Empower serves as Erie County's Community Parent Resource Center. We are here to serve you and help you with your needs. Today I have from PA Parent and Family Alliance, Christina Paternoster. And what is your title over there, Christina?
Right now we are a project of the Allegheny Family Network, so I'm the project director.
Wow, awesome. And today we have Christina over to talk with us about the mental health consent to treat law, because there was an extremely huge change with that law. And Christina, can you tell me what is the biggest change?
I think the biggest misconception is that there is a change. The previous law, Act 147, was often misinterpreted.
Okay.
And we think that people may have gotten confused because it gives children the right to consent. And so I think that over time, people just thought if children had the right to consent, they also had the right to refuse. And that was incorrect. So what many people had interpreted was that children could, age 14 and over, could override consent for mental health treatment that their parents had given. So we had tried for years and years, advocates fought and fought to really get correct information out. And as I'll go over, I think reintroducing a new law really kind of takes care of that. So Act 147 is no more.
Well, this is a really, really, really big deal due to the fact that, unfortunately, there is a lot of misconception. What are some things we can do to help train those that work with us about the change or the understanding?
So I think that when a parent encounters a provider who is under the misconceptions of Act 147, this really gives them an amazing opportunity to say, did you know that in September of 2020, one good thing to come out of 2020, a new law was introduced. And so there's no more arguing with somebody about what does the law say, what doesn't it say. It's a brand new law that gives us all the opportunity to learn and learn correctly. And they made the law really, really easy to understand. I think that they clarified some things that parents had had some trouble with in the past. For instance, if one parent wants treatment and one parent doesn't want treatment, you know, in the past, we weren't really sure how to handle that. This law makes it crystal clear. It also covers the difference between inpatient and outpatient. So I really do think that if a family member encounters someone who's following what they believed was the old rule, this gives them an opportunity to start the conversation fresh.
That's awesome, because I know as a parent of a 12-year-old that uses mental health services, they were getting ready to already kind of train her into that for age 14 coming. And I was thinking, who in their right mind would have ever given a 14-year-old the opportunity at their age to have that right over themselves, or how to, you know, deny services? Or how did that ever come about? Do you know how it ever came about that it was misunderstood?
So, well, how the misunderstanding started, we have no idea. Yeah, it's just, like I said, I think that people kind of use that associative, is that what it's called, property in math, where, you know, 3 + 2 is 5, and, you know, and 2 + 3 is 5. So they kind of think it works one way and it works the other. And it would be logical to think that if someone could say yes, they could also say no. And there's probably very few instances where you would want to give someone the opportunity to say yes and not say no. But, you know, we'll go over it pretty thoroughly. But again, it's super, super, super simple. And just, you know, just so that, you know, we're really clear, we think it's absolutely fantastic that 14-year-olds have the right to consent to their own mental health treatment. We know when we're having a difficult time, and we certainly want to encourage our youth to understand how they're feeling and to overcome stigma and to ask for help when they need it. I used to run a domestic violence and sexual assault center, so I can say from my lived experience in the field that there are many times that a 14-year-old may want to seek out mental health treatment, and maybe they don't have their parents' permission, or maybe their parents don't know yet. So this is a good thing, giving a child age 14 and up the opportunity to consent for mental health treatment is really fantastic. And of course, we know that our qualified therapists are going to work with their client, that 14 to 17-year-old, to talk to them about the importance of, if they don't want to initially at least talk to their parents about why they want mental health treatment, at least have that conversation, and certainly the therapist can facilitate that conversation with them. So, this is really good. The more people who are in tune with their mental health needs and can access treatment, certainly the better.
Awesome. I actually have a parent response here that says that that's their problem, that they want their child in therapy, but the other parent doesn't want that to happen. And they have split legal custody. And the one parent feels that there's a battle through the courts. And even with the courts, there still isn't therapy. So does she have to wait until the child's of age? Is there anything for children under the age of 14?
So under the age of 14 is just is handled similarly to under the age of 18. Will all be handled the same. In that case, the non-consenting parent can appeal to the court for a hearing, and the court will have a hearing where the judge determines if treatment is necessary or not. But that should be on, there's nothing that prevents a parent from putting their child into treatment. It would be the non-consenting parent who needs to take that responsibility to approach the court and make the argument for why the child should not be or remain in treatment. Okay. So it should not prevent treatment from happening.
Okay, perfect. So as Christina goes through her PowerPoint with us, if you have any more questions as we go, please feel free to put those in the chat box and we will answer them the best we can, because this is brand new to me, but this is you're the girl that knows. So
and just so everyone's clear, we are certainly not medical or legal experts, but we have had this legally reviewed. Mm-hmm. And so, certainly parents could, reach out. I'm sure like the Disability Law Center will review this and such. But when you see the law, super clear. Are you going to be able to, will you put in the chat box, and we'll also, it'll also be on the screen so that people can actually access the law themselves?
Absolutely. What would you like me to put in?
I had emailed you.
Oh, yeah. Okay. You want that link?
Yep.
Okay.
Yep. Okay. So before I babble for like 10 minutes and then you say, I can't see your PowerPoint. Can you see my PowerPoint?
I can see your PowerPoint.
Okay. We're good to go then.
And I'm going to get this in the chat box here.
And I'll tell you, I hate when people read from PowerPoint slides, but I'm going to, in many cases, just because we are talking about the law, and I want to make sure that I'm reading what people will find when they access the law themselves. So April Dugas's daughter, Gabby, developed a severe eating disorder. She became suicidal. She had had a terrible trauma in high school. And, you know, as any good parent would, she really tried repeatedly several places to get her daughter into treatment. But because her daughter was over the age of 14, Mrs. Dugas kept hearing over and over again, she has to sign for her own treatment. She has to consent to treatment. And of course, as many young adults do, she didn't really feel that she needed treatment. She wanted to talk to a therapist. And Ms. Dugas was never able to successfully get her daughter into the treatment that she really, really needed. So after her daughter's unfortunate death, Ms. Dugas approached her local representative, Jason Ordite, here outside Pittsburgh, and she explained her situation and she asked for a solution. 6 long years, it took 6 years we've been waiting, but we're really pleased to announce that Act 65 of 2020 is now a law, and it provides us with the opportunity to correct some of the previous challenges that we've dealt with. So let me give you a quick summary. This act amends the February 13th, 1970s act that was previous to this. It allows children aged 14 and up the opportunity to consent for their mental health treatment without parental consent and without worrying about their consent being overridden. Now, just to be clear, parents can also provide consent without worrying about anyone overriding their parental authority. And here is the actual law, the whole thing. You can type into Google Act 65 of 2020, Pennsylvania, and you should be able to find the whole law. I'll warn everybody, don't just type in Act 65, Pennsylvania, because I think it's like a Social Security law. You really have to type in 2020. So let's talk about outpatient treatment first. So the following shall apply to consent for outpatient treatment. Here's the legal stuff. A minor aged 14 years or older can consent to treatment, does not need parents' consent. And of course, a parent or legal guardian of a minor under age 18 may consent to voluntary outpatient mental health exam, treatment on behalf of the minor, and the minor's consent is not necessary. You'll notice that word voluntary is in yellow. We'll talk about that in a minute. Here comes the $25 word here. A minor may not abrogate consent provided by a parent or legal guardian on the minor's behalf, nor may a parent or legal guardian abrogate consent given by the minor on his or her own behalf. So I don't know why they have to use such a fancy word like abrogate, but let's go over it. Abrogate means to abolish by formal or official means, to annul an authoritative act. So I love synonyms. So when we look at the previous slide, we can think, you know, a minor does not have the right to annul. A minor does not have the right to invalidate or undo the consent that their parents give. So abrogate is one of those, you know, fancy legal terms, which means override. So let's talk about some scenarios. And if you're joining us, if you'd like to look, you could give us a thumbs up if you agree as we're going through this scenario. So a therapist has been working with 14-year-old Abby concerning her eating disorder. They've been working together for about 6 weeks. It's the longest Abby stayed with a therapist. And Abby's on the verge of a breakthrough, and you know, it's really uncomfortable, so she doesn't want to go any further. Abby wants to fire her therapist. She wants to stop going to therapy. The therapist really feels that Abby is exhibiting avoidance with the issue at hand. The therapist feels that they can continue to work together, and a breakthrough will happen. Abby's fired her last 3 therapists, but Abby's parents want her to continue with this therapist. Give me a thumbs up if you think Abby has the right to fire this therapist. So I'll say that because the parents give consent, Abby does not have the right to opt out of therapy and fire the therapist. Abby needs to continue with therapy. And certainly her therapist is really going to talk with her about, you know, how she feels and why she doesn't want to come to therapy anymore and how uncomfortable therapy could be. But because the parents have given consent for Abby to receive treatment from this therapist, Abby needs to continue to receive therapy. So let's look at it a different way. 17-year-old Alyssa, with the help of her school guidance counselor, has sought outpatient therapy due to her feelings of anxiety. Her father's aggressive behaviors and verbal altercations with her mother make it impossible to even think when she's at home. After the first month of outpatient therapy, Dad finds out. Probably the bill came in the mail. Dad's furious and demands that Alyssa terminate treatment. Does Alyssa have to stop outpatient therapy? Could give me a thumbs up if you think Alyssa needs to stop outpatient therapy. So I'll mention that Alyssa does not. Dad does not want her to go to therapy. Alyssa wants to attend therapy as long as one of the parties, the child or the legal guardian, wants treatment to continue, treatment will continue. So let's talk about consent for inpatient treatment, a little different. Inpatient treatment, outpatient treatment, two different things. So let's talk about those. So a minor's parent or legal guardian may consent to voluntary inpatient treatment on behalf of a minor under age 18 on the recommendation of a physician who has examined the minor. Okay. The reason why we talk about that, voluntary and involuntary, again, we'll get into that in a second. A minor 14 years of age and older may consent to voluntary inpatient mental health treatment on his or her own behalf. And here comes that word again. Neither party may abrogate consent provided by the other party. So neither party can override consent. So we talk a little bit about voluntary treatment, and that's because we know that in Pennsylvania, we can, in shorthand, we call it 302ing someone, which is an involuntary commitment. So an involuntary commitment, the definition is it's an application for emergency evaluation and treatment for a person who's a danger to themselves or others due to mental illness. A person applies for an Act 302 because they're concerned about another and they're who refers them. So a lot of times we see this if someone attempts suicide, they will go to the emergency room, and at that point a doctor could send them for further treatment as an involuntary commitment. An involuntary commitment, nobody can override it. The child cannot override it. The parents cannot override it. It's a it's requires a medical professional to make use their opinion that this is necessary treatment. So it's not up to mom or dad. So when we talk about voluntary treatment, what we're talking about is treatment that the parent, the medical professional feels is required for a more intensive therapy. Usually these are like residential treatment facilities, perhaps drug and alcohol treatment facilities. There's no hearings for a voluntary treatment. It's not required that there's a hearing. There's no information submitted to state police regarding psychiatric treatment. So that's something that's concerning for people. People worry if I put my child in a residential treatment facility, will there be some kind of long-term record? Will this be, an adverse situation for them? And in this case, it being a voluntary treatment, it is not. So understand that voluntary treatment is very different. So when we use that word voluntary, it's not medically necessary or legally required. So let's talk about another scenario. Here we have 16-year-old Jacob, who's in need of a residential treatment facility due to his sexually problematic behaviors against his 10-year-old sister. Jacob doesn't want to go into a residential treatment program and has agreed to remain in outpatient therapy. but mom wants a higher level of care to make sure that her other children are safe. And she really wants Jacob to receive that level of care that he needs. He's getting older. Certainly that's probably, first and foremost in mom's mind. So while searching for the proper residential treatment facility, mom is told over and over, because Jacob is 16, he's going to have to agree to voluntarily going into an RTF. So give me a thumbs up if you think mom has the right to sign for voluntary placement for Jacob. Luckily, we know that due to Act 65 of 2020, there's no discussion anymore. Certainly a parent can consent to treatment for their child, and Jacob, as a 16-year-old who may not want to confront some challenging behaviors, probably really doesn't want to go to inpatient treatment. Luckily, the more mature and understanding parent could really make sure that he gets that treatment that he needs to be successful. So let's talk about how consent works for inpatient treatment. A parent or legal guardian who provided consent to inpatient treatment may revoke that consent. Inpatient treatment will only continue if the minor provides consent. So you do have the right to change your mind. A minor who has provided consent may revoke that consent. Treatment's only going to continue if a parent or legal guardian steps in and provides consent. So what happens? At the time of admission to an inpatient treatment facility, someone who works at the agency is going to talk to the child and explain what's going to happen. So this is the program, this is how it works. Really let them understand what their treatment is going to be, which again, we think is very important. So a statement of the minor's rights to object will be explained, and they'll be given a written copy. And if the minor wants to exercise their right and say, I don't want to be here, the director of the facility will provide the minor with a notice of request for modification or withdrawal from treatment. And at that point, once the child signs it, the representative from the agency will file the signed petition with the court. After it's filed, a court has, they'll appoint an attorney, and they'll hold a hearing within 72 hours. And at that point, the judge will look at where the child is, why they're there, perhaps what else has been tried, and really make a determination to take the minor's best interests at heart and make sure that this is the right place for the child. So the big question is always, where is the child during this proceedings? Do mom or dad or grandma or whoever has legal guardianship, do they have to take the child home? They stay at the residential treatment facility until the judge determines that they can no longer stay. So they stay put. How long are they going to be there? Well, a minor who's ordered to undergo treatment will remain and receive inpatient treatment for up to 20 days. At the end of that 20 days, if they're ready to go home, they go home. If not, we're going to ask the young adult, maybe during that 20 days, they've kind of gotten over that hump where they don't want to be there, and they go, I'm going to stay. So if the minor chooses to stay, that's great. They can just stay, notify the court, everything is good. If not, the cycle starts again, where the attending physician sends the information to the court, and the court makes the decision they should stay for 60 days or they should release the minor. And this just continues until either the child says, yeah, I'm good staying here, the treatment has ended, or they go through another 60-day cycle where maybe the judge says, all right, no more treatment, or you can stay. This is the question we talked about a little bit before. So what happens when parents don't agree? This can happen to parents who are married, sharing the same home. It can happen to parents who are separated. It can also happen in a case where maybe there's a legal custody of maybe a grandparent, but maybe a parent still has some of their parental rights. So if the parents disagree to inpatient treatment, again, the non-consenting parent needs to go to the court and file a petition where the child resides. So, you can't pick where you want to go. You need to go to where the child lives, sign a petition with the Court of Common Pleas, and then the court will hold a hearing in 72 hours. This is a big question. A lot of parents want to know about medical records. And we've had this happen. We've heard this happen. This is one of the things that used to happen in the past, where we were told the child had to sign for the release of their medical records. So a parent or legal guardian, just as with any medical records, can certainly continue to sign to release their child's medical records to, to a treatment facility. And certainly a child themselves may sign to have that information released as well. Okay. We just want to make sure that, that releasing that medical information isn't going to be detrimental to the minor. So there may be some cases where certainly I could imagine a case where maybe there's a parent who is causing some harm to a child. We might not want to make the release of records to that particular parent. So as long as the release of the information wouldn't be detrimental to the minor, and the information goes from one medical professional to another. The parent or legal guardians, they can have, parents want to know what's going on. If their child is taking a medication, I need to know so I can watch for side effects, make sure that they're taking it appropriately. So parents can get, have medical information released to them, and that includes the mental health treatment. So they're coming once a week to meet with a therapist, their diagnosis, the symptoms, medications, and the types of treatment that they're going to do, expected risks and benefits. I sometimes think when parents ask about medical records being released to them, they may think that they're going to be able to read what happens in therapy, and certainly that's not anything that would ever happen. That's strictly confidential. So to wrap it up, 2020 Act 65 allows a minor age 14 and over the right to consent to mental health treatment. Parents, as always, have the right to consent to the mental health treatment for their children until they turn age 18. Neither party may abrogate consent, and as we know, that means they can't override or negate that consent. And parties who are non-consenting to the treatment may object to treatment through the court. Release of medical records can be requested either by the parent or legal guardian, the parent, legal guardian, or the minor, and basic information may be released to the parent or legal guardian. I'm not sure if this will come through. Let's see.
It has. It's not playing, but is there sound?
Just a little. So short and sweet, everything that I just shared with you. Really nice, easy to understand, basic information. You can follow us on any of our social media channels. We certainly have our little mental health consent to treat commercial ready to go. And if there's any questions, I'm more than happy to take them. But thanks everybody for your time and your attention.
That's awesome, Christina. Thank you so much. And then I know I forgot to ask you the one question, and your opinion was, is it worth sending your child to treatment if they're unwilling to take part? Can we review that part again real quick in your opinion? Because that's hard. I mean, now that the law is on your side, what do you think?
So we talked about this one day this week. on our Facebook Live, because, you know, parents are like, you know, why am I bothering? Taking a child to therapy is time intensive. You have to, like, as the parent, you have to leave wherever you are, if it's at work or, you know, wherever, pick them up from school, take them to therapy, wait patiently, and then reverse the whole process. Unless you're one of those lucky school districts that have mental health services right in their school. Isn't that amazing?
Mhm.
It's expensive. So parents do wonder. The trick is that therapists are used to what they consider to be resistant clients. There are many reasons why people don't want to go to therapy, and in many cases, why they're mandated to go to therapy. The court, for instance, may mandate someone to go to drug and alcohol treatment. They don't want to be there. A good therapist will learn how to relate to your child and make them feel comfortable and talk about what the child feels they need to talk about. It may take a while, you know. Therapy, to really, the therapist needs to gain the trust of the child, of the young adult. And certainly when they hit like a certain age, 12, 13, older, right? They're a little resistant. There's some stigma to going to therapy. I think it's always nice now that some of our famous people are coming out and saying like, oh, I definitely talked to my therapist. And it's kind of become more of a thing to go and talk to a therapist. But once a therapist really wins the child over and gains their trust, they can kind of get to the core of what they need to get to. One of our family support partners is actually a licensed social worker, and she talks about how when she was working with a child, they walked into her office and they turned the chair around and they sat there with their backs to her for like the first 3 or 4 sessions. And it took a while for her to win their trust. But, you know, eventually, who doesn't like going and being able to talk to somebody for 50 minutes who goes, you're right, I understand. So give it a try, get them in the door, you know, make a commitment to try for about 6 weeks and see how it works. Make sure it's the right therapist for your child.
I agree. I I'm picky, so I've been through a couple myself. You know, for example, I had somebody that wanted to teach tapping right here. Well, there's tapping in other places that won't become a problem,
right?
Tapping your face. So you have to be still advocate for your child when you're trying to find the right fit. Absolutely.
You
so,
do. You do.
We have somebody that had to leave the meeting, but they said that they appreciate all of the information today and applaud your support of parents and children seeking treatment. And they thank you for the link. And that's all the questions I have. Does anybody else out there have a question for Christina? Because she's right here. And I know they are doing a full week of information at the PA Parent and Family Alliance. They're celebrating how long? It's a birthday, right? You're celebrating your birthday?
We're celebrating our birthday. We're celebrating our 3rd birthday.
That's awesome.
So we are young. We are so lucky though that as I mentioned, we are a program of Allegheny Family Network. They've been around for 20 years. So we are really standing on the shoulders of some really amazing, you know, well-trained, supportive people who are, you know, there to guide us and make sure we have everything that we need. And so really they've given us the wings to take the great work that they do in Allegheny County across the state. And we're just so grateful. We've met so many phenomenal parents, and, you know, we've started a membership, which currently is free. So if you're interested in becoming a member, you receive our blog posts and all the information on everything we're doing first before everyone else. You could check us out at the Parent and Family Alliance. And we do have a 1-page tip sheet in both English and Spanish on the Mental Health Consent to Treat Act with the link to the law. So you can share that with your therapist electronically. They can open the law and look at it themselves. You could share it with friends, you know, people who you know are also struggling.
And everybody can also find you on Facebook, PA Parent and Family Alliance.
Yep.
And this week you'll still be on every day at noon
And 7.
At 7.
Yeah.
So I've been popping in. She had a good idea. No, I think it's fantastic because I've been popping in. I've been there. So it's been fun, and there's a lot of tip sheets, and I really like the fact that the tip sheets you researched amongst families and parents to find the best resources you could. So, I thought that was genius, and I've been enjoying it.
Well, that's really the thing that differentiates the Parent Alliance from other places is the fact that we are all families with the lived experience raising, or we've raised children with behavioral or mental health challenges, substance use disorders, learning disabilities. So we've walked in your shoes, and we may, every experience is different, but we've certainly been there, and we understand what it's like to worry about our children.
Absolutely. And I want to thank you for coming on today, Miss Christina. I've enjoyed the information, and I cannot wait to get it out into our YouTube channel, Mission Empower, and on our Facebook page, Mission Empower as well. It is an important, not change, because you said it's not a change, an understanding, an important understanding of what the rights and responsibilities are for the child and for the parent. So thank you for the information.